Okay, let's get started then. So again, hi everyone. My name is Jesse. I'm from the TorontoJobs.ca events team, and today I'm going to be interviewing Waheeda Ekhlas Smith. She's a employment lawyer at Smith Employment Law, and she's presented at another one of our events in the past. So Waheeda, you're going to be covering today employment law in relation to COVID-19, commuting tests, vaccine, and the workplace, which is obviously a really hot topic right now. People are really curious, I think. So for some background on Waheeda, Waheeda is an experienced Toronto employment lawyer. She's successfully represented both employees and employers in a variety of employment law matters. And prior to becoming an employment lawyer, Waheeda worked as a legal assistant for many years. She started at just 18 years of age. She's appeared at various Ontario courts and tribunals, including the Ontario Superior Court of Justice, Ontario Labour Relations Board, and Small Claims Court. Waheeda has represented clients at numerous examinations for discoveries, mediations, pre-trials, and motions. So Waheeda, I'll let you take it away. I will come on at the end of the session as well to give you a quick outro and let everyone know what's coming up next. All right?
Sounds good. Thanks everyone for being here, and thank you, Jesse, for the fine introduction. As Jesse mentioned, I'm Waheeda Ekhlas Smith, and I am the founder of Smith Employment Law. I have many years of litigation experience as well, and today I'm going to be speaking to you about the COVID-19 in terms of commuting, tests, vaccines, and the workplace. So the first question that I've been asked, and as many of your clients have been experiencing, is employees are saying, I'm afraid to take transit to work. Do I have a choice? So as many of these people are experiencing, despite the increase in vaccinations and businesses opening up after this latest lockdown, employees remain fearful that a return to work is unsafe because of their concerns related to their daily commute to and from work. And they're asking whether they have a right to refuse this work because of the safety issues. So, as you're aware, under the common law and occupational health and safety legislation, employers have a legal duty to take every precaution reasonable in the circumstances to protect the workers. Employees are also entitled to expect that that workplace is safe on their return. Now, in the past, an employer's health and safety obligation generally didn't extend to the worker's commute. And this was primarily because an employer just couldn't control the conditions of how that employee got to and from work. What the employer does have control over is whether that worker physically attends at the workplace, where the work can be completed, and when. And there may be circumstances in which requiring that employee to physically attend could be unsafe because of the safety issues on the commute. So in certain circumstances, an employee may be justified in refusing to attend work because of legitimate safety concerns arising from the commuting on the public transit. Now, the key is communication. If that employee is refusing to return to the workplace because of concerns, whether it's going to be justified, that refusal depends on a number of factors. So one of them is whether they or someone they live with has a heightened risk of serious illness or death due to COVID-19. So advanced age, pre-existing condition, and they're not so far eligible for the vaccine or haven't yet been able to secure one. Second is whether some or all of that work can be completed remotely from home. Third, whether the tasks can be redistributed among staff to allow work from home. 4, the availability of affordable alternate modes of commuting to and from work. 5, who's going to pay for the cost of any alternate modes of transportation. 6, the safety measures being taken by local transit to ensure passenger safety, such as mandatory masks and reduced capacity on the vehicles. 7, whether that work schedule can be modified to allow for travel during non-peak commuting times. 8, whether the work week can be compressed to reduce travel days. And 9, whether that employee is provided personal protective equipment such as face masks, gloves, and hand sanitizer for use on public transit. And of course, this list is not exhaustive or applicable really in every scenario. So again, as I mentioned before, the communication between the employee and the employer is vital. So if the employee says to his or her employer of any special needs or restrictions because of personal circumstances, that employer is entitled to seek the appropriate documentation to substantiate the specific restrictions or needs. And there may be a variety of solutions, as I mentioned, to ensure a safe commute. So the key is that if that employee is unable to perform the essential duties of his position, even with reasonable accommodations, they might have a right to be placed on a temporary leave of absence until such time as it's safe to return to work. So that's the question regarding commuting to and from work, and it's obviously a developing situation. The next question that I've been asked frequently and that a lot of people want to know is, can an employer make its employee take a COVID-19 test as a condition of returning to work? And we're all lawyers. The short answer is it depends. It can often depend on the specific workplace and whether other less invasive measures are available that can satisfy the employer's workplace health and safety obligations, as well as local public health directives. And as everyone watching today might be aware, employees are entitled to expect that that workplace is safe to return to work. So again, under common law, and in Ontario, the Occupational Health and Safety Act, and other comparable legislation, provincially regulated employees are obligated to keep their workers and their workplaces safe from dangers and hazards, including taking every precaution reasonable under the circumstances. Now, depending on the nature of the work, employers may be required to implement some or all of these lists of precautions that I've got on the slide there, as it's appropriate to those workers and workplaces. And some of the things that have been used and are recommended are: 1, to provide personal protective equipment, such as masks, sanitizer, and gloves. 2, regularly cleaning and sanitizing the workplace. 3, requiring employees or contractors to stay at home if they're suffering from known or suspected COVID-like symptoms or having been diagnosed as being COVID-19 positive. 4, conducting temperature checks. 5, requiring employees and visitors to maintain physical distancing. 6, putting spacing between workstations and desks. 7, requiring employees or visitors to the premises to declare whether they've recently returned from international travel. 8, implementing rotating shifts and staggered shifts and breaks. And 9, implementing work from home protocol for those staff whose physical presence is not actually required. And again, this list is not exhaustive, as you can imagine. However, if an employee's physical presence is required at the workplace, and they're providing an essential service or they work with vulnerable individuals, requiring that employee to take a COVID-19 test may be an appropriate measure to meet those health and safety obligations. At the same time, employers have to be aware and cognizant of their employees' right to privacy, including privacy about their personal health, as well as to make sure they're not breaching human rights legislation and their employees' dignity. So the employer should ideally make clear the reasons why the medical test is needed in the circumstances and ensure prior informed consent. They should explain how they will use and dispose of the information from the test and protect that person's privacy as much as possible. And only require the least intrusive means of testing necessary in the circumstances. Now, having said that, there was a recent case in late 2020 that addressed mandatory COVID-19 testing in the context of a workplace. This situation, though, was a unionized setting, specifically a retirement home. The decision here was made by an arbitrator at a tribunal, and most importantly, the employees here worked with high-risk elderly individuals. So in this case of Crescent Care Nursing Retirement Homes and Christian Labor Association, the arbitrator considered the union's arguments that mandatory COVID-19 testing should be analyzed similarly to drug and alcohol testing cases, where the Supreme Court of Canada had decided that random alcohol testing through a breathalyzer did not outweigh the potential breach of privacy rights. At the end of the day, the arbitrator in this case decided that mandatory and preemptive testing was appropriate, saying, COVID is novel, thus its name. Public health authorities are still learning about its symptoms, its transmission, and its long-term effects. What is known is that it is highly infectious and often deadly for the elderly, especially those who live in contained environments. And I emphasize the point where it says, in my view, when one weighs the intrusiveness of the test, a swab up your nose every 14 days, against the problem to be addressed, preventing the spread of COVID in the home, the policy is a reasonable one. She went on to say, while the home had not had an outbreak, I agree entirely with the employer that given the seriousness of an outbreak, waiting to act until that happens is not a reasonable one. So in this retirement home case, the highly infectious nature of the virus, the vulnerability of the elderly residents, and the potentially fatal consequences justified the intrusion on employees' privacy. What we have to remember, though, is there's not yet been a court decision that answers whether mandatory COVID-19 testing would be reasonable in all workplaces. My personal speculation is that mandatory COVID-19 testing policies will not be considered reasonable, and that the needs of and circumstances of each workplace will need to be considered carefully. Once that policy is finalized, though, it should be clearly brought to the attention of employees before it's put into operation. The employer should also let the employees know of any consequences of failing to follow the policy, and then be consistent in enforcing the policy. So while I would venture that employers might have more leeway insisting that an employee take a COVID-19 test over mandating that they receive the vaccine, employers have to balance maintaining a safe workplace with making sure they're not excessively intruding upon individuals' privacy and human rights. So linked with that is the question about, well, can you make COVID-19 vaccinations mandatory? How can you ensure your employees are vaccinated for COVID-19? What are some of the considerations for and against any kind of COVID-19 policy? Are there less restrictive options available? Right now, COVID-19 vaccinations are not readily available to the general population and will likely not be for some time. And while provinces are authorized to order compulsory vaccinations, at present there's no governmental directive for mandatory COVID-19 ones, and there never may be. Again, Ontario courts haven't yet ruled on whether mandatory COVID-19 vaccines are legal or not. Now, as you may be aware, there are specific workplaces, such as daycare centers, where the operators must ensure that the workers have received the recommended immunizations in accordance with public health directives and regulations. For example, in the City of Toronto, the medical officer of health has recommended for the workers at a daycare to have the hepatitis B vaccine, MMR, Tdap, chickenpox, and the seasonal influenza vaccine. But as expected, there are exemptions on medical grounds and conscience and religious beliefs. So similarly, once COVID-19 vaccinations are available to everyone, employers who want to implement these mandatory vaccinations need to again balance workplace safety obligations where they're expected to keep employees safe against those same employees' privacy rights and human rights. Now, these privacy rights include an individual's personal health and the right to bodily integrity. And generally speaking, employers cannot breach employees' dignity and force a vaccination without the employee's consent. And furthermore, pursuant to human rights legislation, an employee can seek accommodation and refuse to be vaccinated on a number of prohibited grounds of discrimination, such as disability, sex, including pregnancy, religious beliefs, or creed. Now, in such a case, the employer has to determine if they can meet this accommodation request without undue hardship, such as, can they allow that employee to continue working from home? However, if a non-unionized employer wants to implement a mandatory COVID-19 vaccination policy for its workplace, it can be guided by the KVP criteria that was first established in the 1965 arbitration case, and I've got the citation there in the slide. This 6-part test was later endorsed by the Supreme Court of Canada in a 2013 case, and I can provide that citation as well. It's the Irving paper case. That 6-part test said this policy must be consistent with the collective agreement. It must be clear and unequivocal. It should be brought to the attention of the employees affected before the employer attempts to act on it. Where that rule is invoked to justify discharge of the employee, that the employee was notified that the breach of rule could result in discharge. And finally, did that employer consistently enforce the rule since it was introduced? So applying those KVP principles or criteria to a mandatory COVID-19 policy, an employer should, if possible, do the following: assess and be able to explain why less intrusive measures such as physical distancing and the use of personal protection equipment and wearing of masks were not sufficient. To avoid that one-size-fits-all approach and tailor their policy to the needs and challenges of its specific workplace, retail versus healthcare versus other similar environments. Make sure that the policy is clear and shared with those employees well before implementation. Assess whether there would be any repercussions for noncompliance. Outline those penalties, and then ensure that the policy is routinely enforced. 5, accommodate employees who seek an exemption on the basis of human rights. 6, for those employees who cannot be accommodated without undue hardship, be able to justify the policy likely as a bona fide occupational requirement. And 7, ensure that any employee personal information showing vaccination or any request for accommodation be kept private and secure. So doing a fact-specific analysis and tailoring any vaccination to that specific job site should help that employer surviving any legal challenges that come up where the employees, for example, are challenging the policy. Now, once there are enough vaccines available for everyone to avoid running foul of employees' contractual, privacy, and human rights, some employers are considering other methods of encouraging greater compliance, such as offering paid time off for workers to receive the vaccine, and or setting up mass vaccination clinics on site to minimize inconvenience and disruption to the employee, while of course allowing them to continue to get paid. Another option is if the provincial government offers paid time off to receive the COVID-19, such as what Saskatchewan began allowing as of several days ago, this can further incentivize employees and encourage greater compliance. Specifically, Saskatchewan's occupational health and safety regulations were amended to add a new vaccination leave where workers are now entitled to 3 consecutive hours of leave during work hours to receive a COVID-19 vaccine. And it's been estimated that usually each appointment could take from 2 to 4 hours for the person to attend, have the vaccine, and then return to work. Second, they're entitled to more than 3 consecutive hours if the employer determines that a longer break is warranted. And finally, this new regulation allows that employees do not lose pay or other benefits while receiving their vaccination. So in conclusion, there remains a great deal of speculation on whether and then how to implement COVID-19 testing and vaccination policies at a workplace. Until or unless the courts decide on the issue or the government directs mandatory testing and vaccination across the board, my recommendation is that employers create custom policies appropriate to their workplaces while balancing those collective safety obligations with their employees' privacy and human rights. And thanks for listening. And one of the questions is, will we be able to get a copy of the slides? Yes, I'm happy to send those to you. I'm happy to send it to Mark and Jesse to forward if you wish. But if you're wanting to contact me on LinkedIn or sending me an email, I will put my email address in the chat, and I will forward you the slides at your convenience.
Hi, Waheeda.
Hi.
Thanks so much for that presentation. You know, I kind of was doing other stuff during it, so I didn't hear all of it, but, you know, definitely some really great insights. You know, a lot of employers definitely are wondering about, you know, can I make the employee take the vaccine or not? You know, probably the employment lawyers in this chat would make some better insights than I have. Anyway, so again, thanks so much for presenting, and thank you to everyone in the chat for coming out and watching Waheeda's session. We have 2 more sessions coming up after this, which are going to be in the sessions tab on the left. Or sorry, one more session. It's by Jordan Rodney from Rodney Employment Law. It's going to be on employment law lessons from the pandemic. You're also welcome to go into the networking area, which is a link that you can find on the left as well, and that'll allow you to video network with anyone at the conference. And at the end of the event, we'll also have an employment law panel, so we're excited to see you there as well. Again, if you have any questions at all for Waheeda, feel free to email her. She's got her email address in the chat there. You can also connect with her on LinkedIn and check out Smith Employment Law. And again, thanks so much for coming out. It's great to have you all here. Waheeda, thanks again.
My pleasure. I hope that was helpful, everyone. Thank you.
Absolutely. All right. Have a great afternoon. Bye-bye.
Bye-bye.